There it is. Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for January 21st, 2026. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I will call our afternoon case today is cause number 2022 DCB 3599, Myrna Yolanda Quiñones et al. Versus Greenwood Motor Lines et al. May I have announcements, please?
Good afternoon, Your Honor. Daniela Lebinalti and Jeff McElroy for the plaintiffs.
Good afternoon, Your Honor. Jaime Peña, Jeanette Garcia, and Bill Minucci on behalf of the defense. We're ready to proceed.
And we are set today, somewhat of a continuation of the hearing that we had. Golly, was it on the 12th? The 12th of
Yes.
January?
Yes, Your Honor. I believe all the experts testified, and I think the testimony of the experts concluded. I believe Mr. Peña asked for the court to hold off the ruling because they were arguing to the court that somehow their experts were lacking some of the medical records, even though they were sent to them at least in December. But
So
either way,
hold
I
on a
did
second.
argue.
So let me interrupt you real quick. So what I understood, Mr. Peña, you were going to do an audit of the medicals in light of all the testimony that we had on that day to verify that there was nothing outstanding. What is the result of your audit?
Your Honor, I'm going to just verbally give you a summary of the result, but then Ms. Jeanette Garcia actually conducted the audit and she can give you some more specifics.
Okay.
We took a look at the productions that took place in this case, and as the court pointed out at the Daubert hearings, quite frankly, which from our perspective, the evidence is not closed on, but the court pointed out that there's a disconnect going on here with regards to an MRI that supposedly took place within roughly 6 months. The experts that we proffered to the court, Dr. Santos and Dr. Nadal, were relying on MRI films that took place about a year after the accident. Ms. Labinati extensively cross-examined them based on MRI films that they did not have and hadn't seen. Well, it turns out, Your Honor, that the discovery had closed on November 5th. On November 10th, Ms. Labinati and the office produced a bunch of records that we'd never seen before. One of the records, or actually two of the records from June of 2021, indicated that Dr. Johnson had seen some MRIs from a Legent hospital. We had never even heard of Legent Hospital in this case in any of the records that we had seen. We didn't know that there were MRI records associated with Legent Hospital. And so it came as a complete surprise. It wasn't until December 10th that we received those records. And quite frankly, we were ambushed at that Daubert hearing.
Hold on a second. Hold on. So you're saying December 10th? I had heard of November 10th.
Oh, no. November 5th was the date that the discovery closed. December 10th was the date that those documents were produced. They did not include the MRI films, but there is a reference in two of the records to Legent Hospital in records that we'd never seen before, frankly. And by the way, which are not reflected, Legent Hospital is nowhere reflected in any of the initial disclosures or responses to any of the written discovery that we've provided.
Okay.
Let me know when you want me to respond, Your Honor.
Well, let me hear from Ms. Garcia. And so I want to kind of just have my own mental timetable here. The original special setting was the 5th of December. We had our motion for continuance hearing back in October. Golly. Okay. All right, Ms. Garcia, go ahead.
Is it okay, Judge, if I share my screen so I could present you the chronology we prepared for you?
Sure.
And can you see my screen, Judge?
Yes.
So what we did here, Judge, is we went through all the medical records that we received from plaintiff's counsel regarding these MRIs and specifically Dr. Johnson. I noted the dates that these medical records reflect, the dates they were received, how we received them, and by who we received them. So initially, Judge, when this case started, we received medical records from Dr. Johnson. Here it notes September 14th, 2023. And I want to point out, Judge, that here in the chronology of the medical records that we received, it notes May 26, 2021 is when plaintiff, our belief, initially sought treatment with Dr. Johnson. And then after that, she presented again with Dr. Johnson March 25th, 2022, continued treatment in 23, and then the last treatment date we have for this record is September 1st, 2023. Again, the medical bills that we received in September 14, 2023 reflect exactly the medical records we received. We move along through time. Now we're in August 2024. Plaintiff's counsel presents their plaintiff's second supplemental notice to intent to use billing records. In these records, she supplements with treatment dates from September 28, 2023, noted through April 3rd, 2024. We continue. Now we're in September 10, 2024. Again, we receive additional medical records from 23 through 24. On September 10th, the medical bills reflect what has been previously produced. Additional treatment date for June 12th, 2024. Then, Your Honor, we ourselves prepared DWQs to Dr. Johnson's office. Same thing.
Hold on, Ms. Garcia, let me make sure I'm understanding. On that last number 4 and 5, there is a June 12, 2024, right? Treatment
Oh,
date.
yes. And the medical bills reflect the same thing that, yeah, that they reflect the same thing that as treatment is ongoing and time passes, plaintiff is continuing to supplement discovery for that later treatment dates.
Mhm.
And then we do our due diligence and we sent over DWQs as well to Dr. Johnson. Same as I put as same as number 3, the same medical records that we already received from plaintiff's counsel. We received from Dr. Johnson through DWQ. At that same time, which is we're in March 19, 2025, we also submit DWQs to Dr. Johnson requesting any radiology records. We receive that DWQ back and it notes none, no radiology CDs or films. Okay, we move on. Now we're in May 22, 2025. Medical bills, we received more medical bills from DWQ. They reflect the exact same things we have already previously seen and plaintiff's counsel has already produced. We now go down to June 3rd, 2025. We receive medical records through email by plaintiff's counsel. Again, same records, it's just as an additional record for treatment plaintiff underwent February 27th, 2025. Medical bills on that same date reflect the records and the treatment. So she has additional treatment February 27th, 2025. The medical bills reflect that as well. Again, we received our own records from Express Records. No additional medical bills, dates, same as what we've reviewed above. So, Judge, these that I just went through, number 1 through 11, these are the records that we've received through discovery, right? Through supplemental disclosures, DWQs, affidavits, and these are 1 through 11 are the records that ourselves we've reviewed, we've relied upon, our experts reviewed, our experts relied upon. Then, Judge, I want to point out to number 12, which this is the critical issue. On December 10th, 2025, we received something called Plaintiff's Exhibit 17. In these records, these medical records then contained medical records from treatment in 2021. So, and I'm just going to go back a little bit, Judge, on the top. As you see throughout this entire litigation, it was our understanding that plaintiff only sought treatment one time, May 26, 2021, with Dr. Johnson. It wasn't until last month, December 2025, that we received records in 2021 from Dr. Johnson, which was Plaintiff Exhibit 17. Those records are February 2nd, 2021, May 21st, 2021, and May 29th, 2021. What's critical about May 29, 2021 is that plaintiff underwent 3 x-rays that were not reflected on any of the other medical records because we did not have these records. What's even more critical, Judge, if we look here, June 9th, 2021, June 28th, 2021. In June, there's an MRI at Legion Hospital to the right shoulder. And then on June 28th, there's an MRI at Legion Hospital to the lumbar spine, L5, S1, L4, 5. These are the records, Judge, as you recall at our last hearing, that plaintiff's counsel cross-examined our expert with, noting you've never seen these records, you don't have these records. She extensively talked about these records. Well, these records were never disclosed, never produced until December 10th, 2025. And I'll continue, Judge. There's more records after these MRI records in 21. August 16th, 21, August 31st, August 13th, and then there was a February 1st, 2022 record. All these records were produced for the very first time where plaintiffs sought treatment in 2021 last month. And more critical, Judge, it's noted, as you see here in Dr. Johnson's report, MRI at Legent, he notes reviewed from portal, but there's no date. So when were these MRIs taken? When did you receive these records? We've never seen a report. We've never seen, till this day, we're still missing the report, the radiology films. We still don't have that. All we have is Dr. Johnson referring to these MRIs and these findings. We don't know if these findings were Dr. Johnson's findings, the radiologist at Legent, that's still unknown. And then same thing, the records, the medical bills that we received, Plaintiff Exhibit 18, reflect the above that we just went through. Additional treatment in May of 21, June of 21, that was never seen before. And Judge, if you would just allow me to just give you a quick example of how it looks, just so you could kind of see where I'm coming from. This is a business affidavit of records that we received for Dr. Johnson. This is what we're looking at to cross-reference with our medical treatment. So here it notes May 26, 2021, which we noted from the very beginning. Then it shows that the next treatment was until March 25th, 2022. So all those 2021 medical treatments that we just went through where she received those 2 MRIs at Legent, not noted in the bills. We go through the bills, 22, more treatment in 23. Plaintiff continued to seek treatment in 24, and then it stops right here. February 27th, 2025. And then if we look at the bills that we received last month, which was December 2025, it's consistent, Judge, with what we've received. It shows May 26, 2021. Next treatment wasn't until March 25th, 2022. Everything consistent what we've received. It's not till you get to the very last page where you're like, wait a minute, there's now treatment in February of 21, May of 21, all these treatment dates on 21 that have never been disclosed, never been produced. They're produced on the very last page of these bills that we received last month. So even, Judge, by doing our due diligence, cross-referencing our bills and our records, we just received this with this added treatment in 21. So there was no way of us knowing that these MRIs existed, that plaintiff sought treatment. And as Mr. Peña noted, Legent Hospital, where plaintiff received these MRIs, are not listed in plaintiff's fact witness list, plaintiff's expert disclosures, plaintiff's exhibits. We have no records, Judge, whatsoever for Legent, but these are the records that plaintiff was relying on to cross-examine our experts. And I just wanted to lay this out, this chart for you, just so you could kind of see everything we did when we received it. So you could see when we received it. And if you had any questions at all, I welcome them in case, you have any questions on this chart.
No, well, so what I am understanding is that at least a subset of some of this information produced on the 10th of December of 2025 at least one of them, I know for sure, if I remember correctly, was the subject of kind of this questioning back and forth where I know for sure it was Dr. Nadalo. I don't recall completely if Dr. Santos had that same issue just offhand. But all of that was produced to you all on the 10th of December.
Correct, Your Honor, yes.
Okay. No, I don't really have any questions.
With the exception of, Your Honor, what wasn't produced is the Legion Hospital MRIs or the X-rays that were referenced in the medical bills or in the medical records, the newly produced medical
So
records.
those were not produced on December 10th in this batch.
We still don't have them, as a matter of fact. They still haven't been produced.
Okay. Okay.
Let me know when you're ready to respond from Your Honor.
Well, Mr. Peña, Ms. Garcia, do you have anything else? I think I understand. Okay.
Nothing further, Your Honor.
Nothing further, Judge.
Thank you. Ms. Lapinati?
Yeah, Your Honor, may it please the court. So as the court remembers in my right before trial, one of the bases that I asked for continuance, aside from the issue with having my co-counsel recused, was that we had discovered that we were missing medical records. And I had said there's even a wrong MRI that referred to a shoulder when it should have been a back with Prestige, and we discovered that we're missing records as we were doing trial prep with our clients. So we were trying really hard to get that in a very short time notice. And that was, I mean, I put that in the record, should be in the transcript. Mr. Peña told the court, no, don't give her the continuance, we're ready. And anyway, the case was continued. I advised, and I had no idea what I was going to see. I said, you know what, I'm about to get records. I have been calling everybody, sending emails at night, we're missing records. I realized when I was getting ready. And so long story short, I advised them and I did produce what I got. My understanding is that Legion is no longer in business, which is one of the problems and the reason they closed, they went bankrupt. And so I have had no ability to get anything else other the other records, which my understanding was because there was a lot of it telemedicine. There was COVID during this time. This accident happened during COVID, where there's no police report. So there was some records that were in through a portal that were not transferred. And so I was working very hard and diligently to start to get this information that I realized I didn't have. I realized that I couldn't find anybody from Legion. So I got as much as I could. The moment we got them, my office stayed late at night. We put them together because we didn't know if we were going to actually go to trial. So we got them ready and we immediately, we sent as much as we sent to the other side. So that was before the Daubert hearing. They had a notice of a Daubert hearing after I got the records. In fact, my expert testified he had not seen this records himself. He was cross-examined by Mr. Peña on the same subject, and he said, you know what? When I wrote the opinion, I didn't have these records. I didn't review these records. So we went through the with my expert, my own expert, at the date of the hearing, page by page by page. And they're experts. They're hired to give opinions. At no time did my expert or their experts tell this court in a 6-7 hour hearing, we need more time to review that. I read the record. They understood the records. They gave opinions on those records. And their opinions were not modified or changed. They still stuck. Well, the court heard the opinions. So it wasn't like, oh, got you. And they were like, oh, I need time to review. I read it in the record. We discussed it together, the findings. What's more interesting, Your Honor, the MRI, it's the same. So the findings of the MRI on the Legion MRI are almost identical, but I think for the pars fracture, because fracture doesn't cover it on the second MRI because time has passed. Everything else is identical to the Prestige MRI, who they relied for their opinions. And also what's more interesting, Your Honor, is that my motion to strike was submitted to this court before I even had these records myself. The basis of my motion to strike, even without new records, still stands. Like, I did not change my motion. I did not even add the new records. I included in the hearing. But if the court remembers very well with Dr. Nadalo, I even said, let's forget about the new records. Let's forget about the old MRI. Let's focus on prestige MRI. And with Madalo, I specifically, because they were objecting, so I specifically used the prestige MRI for all the cross-examination. And when he says, I haven't seen the lesion, I don't want to talk about it, even though we agreed they were the same, I said, okay, let's focus on what you relied, you relied your opinion or your basis of the opinion. So my motion wasn't on some got you new records. It was based on the old records. And my motion is on the record, is on the system on 1110. And the unreliable opinions on the old records. It's not even on the new records. I mean, that adds on more, but I specifically, especially with Nadal, I was like, you know what? Let's just focus on the MRI. So they're trying to really confuse you. What are the issues or our basis or our motion to strike? Let's not get confused. Let's look at what the facts and the data are. We relied on an unreliable methodology and opinion on an MRI, and let's focus on the prestige MRI. And that was exactly my cross-examination with Nadala. He says that MRI cannot, I mean, he says one thing. The basis of his opinion is only the prestige MRI. He says, I am focusing on MRI because he's not an orthopedic doctor. He cannot give any other basis. So I said, okay, let's focus on the prestige MRI. He says MRI cannot show timing. The court remembers that. Cannot rule out trauma. He said, just because my client is old, that's why his opinion that this accident did not cause the trauma that is documented on the medical records that he allegedly gave his opinion on, which is the prestige MRI, which they've always had and they've based on. He testified the MRI cannot show pain. He testified the MRI cannot show dynamic instability. He testified that the MRI alone cannot show causation as an accepted medical methodology. I said, you know, the doctors rely on the symptoms. The doctors relies on clinical findings. The doctors relies on the complaints of the plaintiff. You agree with me, plaintiff went to the ER. She complained of back pain, numbness, neck pain, shoulder pain. All of these are consistent with symptoms that are as a result of a trauma to the body after an accident. And he agreed with that. He agreed with everything. And he even disputed Santos' opinion that says you got to have a fracture for a disc herniation. So the expert didn't even agree with each other on what the opinions are. So he says, no, that's not true. You can have a disc herniation without having a fracture in the back. Going against Santos' opinion. He testified that degeneration can coexist with trauma. He testified that trauma, he agreed with me that trauma can aggravate or accelerate degenerative condition. He says that he cannot rule out aggravation.
Your Honor, I've got to object. I mean, what are we talking about here?
I didn't interrupt you, so if you can allow me. So my point, Your Honor.
No, hold on, Mr. Pena. Okay, so let me tell you what the crux of my concern is for today. It is not so much, I understand the substantive issues from the opinions, the testimony that we had at the Daubert hearing, 2 weeks ago, however long it's been, 10 days ago. My concern is this. So, Mr. Pena, you stated that, okay, so what's clear to me is that there are several records that plaintiff's counsel did represent in the motion for continuance were newly discovered or pending. I can look at the motion here and see. I think it was the first reason. It was less so, even though I know at the hearing on the motion for continuance, we were really talking about having attorneys available. But the motion for continuance that was filed by plaintiff says, since the current trial setting, critical new medical records have been produced. Okay. And I understand that the timing of that is probably, what we would have all preferred. And certainly the discovery control plan had a deadline much sooner. But there were documents and there were records produced on the 10th of December 2025. I can't assume anything with regard to opinions on whether there were differences, things of that nature. Certainly, I didn't hear a response, or nothing was filed by defendants about these new records. I just kind of feel like they're left hanging out there in December. But my question is this, Mr. Peña, you're saying that with this December 2025 disclosure of Ms. Garcia, that there are still medical exams, I'm not sure if I'm clear if it's x-rays or MRIs, that have not been produced.
That's correct, Your Honor. The Legent MRIs that, frankly, Ms. Labinati strongly cross-examined both of our experts on, and the fact that their opinions were not based on those MRIs that she at least intimated existed.
Hold on a second. So this is what I want to know. I want to know, where are the Legent MRIs? Have those been disclosed to Mr. Peña?
I don't have them, Your Honor. Legent is closed. I have no way of finding out I only have those reports, which is why I then used Prestige for purposes of Nadalo and the MRIs, because I don't have the images or anything. I mean, I have given everything I have been able to retrieve, locate in this unfortunately very old case that some treatment happened during some unfortunate times in our country, COVID. So and then now the facilities have closed. I can't locate anything. I have given everything that I have been able to fix and locate, even with Prestige that we had the wrong image. It was on storage. They couldn't locate it. So I only was able to print like the page, but I still wasn't able to get the actual images even for Prestige. But I have given them everything. They gave opinions on the MRI of Prestige, and they had no problems with that. And my motion to strike was absolutely based on the records they had even before December 10th. And I believe they failed in that respect. They failed on the Prestige MRI. Their opinion were unreliable on the basis of the Prestige MRI, the medical treatment, the urgent care. They literally gave conclusory opinions with regard to those medical records. And with regard to biomechanics, I mean, his argument of there is a fracture of vertebra, and that's the only way you can have a disc herniation. There is no fracture anywhere on even in the initial MRI, but irrespective of that, I focused on Prestige. I started with that and the chronology, but then I changed it to the Prestige because I was like, okay, you're saying you haven't seen this, but let's talk about the records that you have seen. And if the court remembers very well, the biomechanic relied on an opinion that only he has published apparently, and is no else to be heard.
Okay, hold on, Ms. Labinati. So I want to ask, I understand what we heard at the Daubert hearing. Okay, my concern, and where I'm going to go back to Mr. Peña, is what are you so you've heard the representation by plaintiff on the Legent MRIs, right?
Yes, I did.
So we have the only, let me understand, let me hear from you, Ms. Labinati. What do we have from Legent? We just have billing notations that these MRIs were conducted. What else do
I don't have anything from Legent. The only way I found out about Legent was from the portal of Dr. Johnson referring to it. So the reason they were not, I didn't even know myself. I mean, my client says I had an MRI before but I didn't know. And I mean, she doesn't remember. It's an old case. So then when I saw that, then I said, oh, it's Legent. When I try to get a hold of Legent, they don't even have, there is no Legent. Like they don't exist anymore. And so I haven't been able to even find anyone that this could even exist. So I have given everything I have, and we got the telemedicine extra that were missing because they were out of the Dr. Johnson's old portal during the COVID because I think they used another company. And so I was able to get that, but that's all I have. Like, I don't have anything else. And I even tried to get the Prestige because I knew that that was also wrong. They gave me a shoulder versus a back. And I wasn't even able to get that because apparently, because of the age of the case or their storage, I don't have it. So I have
And
given
Rhonda,
them
Hold on a
everything.
second, Ms. Garcia, hold on.
yeah, may I respond? So Legion
no,
Hospital apparently was sold to UMC in 2023. We actually contacted UMC to obtain these records, and they directed us to Legion Hospital in Houston, who they said would probably have the records. They gave us a person's medical custodian number to call. This was as of this week that Legion is still in Houston. They didn't close or get sold till 2023. And so right now we're trying to obtain those records. So I know plaintiff's counsel is saying,
hold on. So, okay, thank you, Ms. Garcia. That's my question. What are you asking for, Mr. Peña?
Your Honor, at a minimum, here's the problem that we've got. I can't rely on Ms. Labinotti's statement that Legion doesn't have records.
I didn't even know you contacted
Your-
Legion.
your-
I don't know Legion.
Your Honor, if I may address the court.
One at a time, please. Thank you.
Your Honor, so what we need to do is make a determination as to what records exist. And, frankly, keep the Daubert determination from the court open and carry it along with the trial. Hopefully we'll have the records and the experts can testify based on these new records that we're just getting on the eve of trial. Aside from that, Your Honor, certainly if we don't have those records going into trial, counsel for the plaintiff should not be able to argue and cross-examine these experts based on records that were never produced and that she doesn't even know exist at this time. So at a minimum, we ask that the court keep the Daubert hearing open, carry it along with the trial, give these experts an opportunity to see the MRIs if they exist and supplement the reports in advance of their testimony. That's all we're asking.
Your Honor, my problem is that I think the experts gave unreliable opinion and my motion was even focused on the old MRI without even needing the other MRI. There is nothing in the MRIs that would change their opinion because
Ms. Labinatti, I can't assume that if we don't have the records. That is my problem. You might be 100% right, but without the record, I can't assume. I mean, there were several times, and maybe I'm misplacing my recollection because there were times when we were referencing things, and particularly with Dr. Nadalo, he was stating that, well, if I had the opportunity to review that, might change, might not change. And that's the problem. I can't assume that something when we don't have it. So I don't even know how. I'm very concerned about even keeping the trial date. I don't have a problem leaving the Daubert hearing open because at the very least, we will have some records and they can supplement. And if there are new concerns if there are changes in opinions, methodology, we have covered up until this point, and they can amend or supplement any other opinions for all of the experts. But the timetable is very tricky because we're set to start. We would probably be having this hearing on the 4th of February.
The issue you have, Your Honor, is that when I got these records to them on December 10th, how come none of their experts looked at the records and say, hey, I am missing this
agree with you
information.
there. On December 10th, I would have expected this issue to come up on December 10th before we had a Daubert hearing. And at that point, but it doesn't cover then still the missing records, which may make a difference, may not, but there's certainly a set of studies that are missing right now.
Well, and my only issue, Your Honor, is that here we wasted hours of hearings. hours of time and preparation on my end, and at no time did they say, hey, my experts need additional time because we were missing additional records, and we just got this record December 10 and we need this additional information. So literally, like, they knew of the hearing, they were so excited to come at the hearing. I mean, we paid experts, and I am not a billion-dollar insurance company like they are, but unfortunately, we had to pay experts money to show up and testify. I mean, I wasted a day of preparation, a day of hearing time, and at no time did this came up. So at the end of the Daubert hearing, at the end of it, it wasn't even in the middle. It wasn't even, at the end of the Daubert hearings at 5 o'clock, 5:15, after the hearing doesn't go too well for them, that's like, oh, well, we're missing the records, even though I saw it coming. So what I did during the hearing is, this why I'm frustrated. I specifically said, okay, well, let's forget about that. Let's just focus on the ones that you based your opinion and relied. That way, because I wanted to, I saw where Mr. Pena was going to go next after our like around 2 or 3 o'clock. So specifically, I started to focus on the records that we had, and I was trying really hard to show the court how unreliable their opinions were on the methodology, on data and ipsy-dixit conclusory argument, based on my initial motion, which was based on the old records. And so that's where I have my frustration on the energy, the time, the effort, the money that was spent on putting all of that together. And at no time did they say, wait, we need this information. But here now at 4 o'clock, after their experts clearly showed in the records that their opinions were unreliable, now it's like, oh, well, let's see if we can come up with an argument so we can run away from the problem, when they all testified that based on their records that they had reviewed, clearly their opinions were unreliable. And so I guess my point is that new MRI, or if there is a new MRI, in the reading, at least as shown in the medical records, is the same. Like, if it was a different MRI, meaning it had a different findings, I could see the argument. It's like, well, it had a different findings. Had I known, but it's identical. So if you look at the shoulder MRI on Prestige and the findings on the Dr. Johnson that it's reading from Johnson, is the same. If you look at the neck, it's the same. So I'm like, okay, like, what is it that in that MRI you think, if it was there, would change your opinions? And so I just feel like this is just another tag. I mean, if we can, like, I think the court can rule just on the old records. And if that's the case, they will need more time. Then this is what I would ask, Your Honor, that the court request from the experts to put in a medical report, not attorney's argument, that they feel that this information would be necessary for them to give the opinion. And I would, if the court can ask that order, and I don't think that's much to ask after we spend all that money to put time and effort, I would like for the court to request from the defendant's expert to put in a report affidavit to the court exactly what is it that they believe that MRI, as dictated by Dr. Johnson that day, would need it in an image that they believe would change their opinions, or it's necessary for them to supplement their opinion.
Lavinati,
I think that's fair.
How can we have an expert sign an affidavit about an exam or a medical record that nobody's seen?
Well, it's documented in Dr. Johnson. So he documents what he reads in there. So that's what
Oh, man. So Miss Lavinati just froze. Mr. McElroy, if you're nearby, you can let her know.
that's what I'm trying to say. Like, based on me.
Miss Lavinati, you're freezing, and it's probably not necessarily your fault. But I think I understand your request.
I just don't think, Your Honor, that their opinions were at any time during the the hearing, they said, well, had I had this information about this part of the report, I would have changed my opinion. They still stuck to their opinion despite me reading what's documented in the record about Legion. So that's
let
my
me,
only thing.
I understand. What would be a realistic timetable if you all are going to pursue requesting these records? I mean, I can't imagine it's anywhere that gets us close to our trial date.
Your Honor, I think that if they exist, we should be able to know that within the week, if they exist.
All right.
And again, Your Honor, I really don't want to go back and forth with Ms. Labinati, but I recall very clearly, not only did the court have concerns, we had concerns. Dr. Nadalo on 3 or 4 different occasions kept saying, I expected the Rincon Law Group to produce the radiology, the films, those sorts of things. It was absolutely critical to him. And again, I think the court's right on point. We don't know what we don't know. We can't testify about things that we don't have in front of us. That's why it has to be produced, and the experts have to analyze them. And that's what all we're asking.
Well, the records I read to both experts, Your Honor, were records that were produced to the Rincon's law firm on December 10, and that Rincon law firm had failed to produce to either of their experts as of January of 2026 at the time of the hearing. So for 1 month, Rincon law firm, their attorney had records in their possession that had not produced to either of their experts at the time of the hearing. So what I read to them was not something that they did not have the ability to have. It was not given to them by the Rincon law firm.
The only thing that is really missing, even though I understand there is a group of records that were, I'll say late, right? Because they were December 10th. The only thing that is missing is these additional Legion MRIs and maybe any, related records. So let me ask this. Of the documents that were produced on December 10th, have those been provided to your 2 experts?
They have.
They have. Okay.
They have now.
And have you requested a supplemental report based on that?
No, Your Honor, they need to see the MRIs. That's exactly why they were hired, as they are radiologists and neuroradiologists. They need to see the films themselves. And again, I have a great deal of respect for Ms. Labinati and for Dr. Johnson, but that's Dr. Johnson's interpretation of documents. We need to look at the source documents themselves. That's what the radiologists do. That's what their expertise is in.
Well, look, you all, meaning you, Mr. Peña, seem very optimistic in that those documents, fingers crossed, you all may be able to get those Legion records within a week. So,
I'm hoping.
Counsel, I'm going to allow that. All right. And I'm not going to require an affidavit. I am just going to allow counsel to get those records. What seems to be like the last batch, right? We haven't identified at this point anything else that's outstanding. And I need to have that update within a week. And as I mentioned, I don't know if it was off the record or on the record, we are going to be in trial. So that's going to mean an email circulated to the court indicating whether we have them or not. Because frankly, if we don't have them by Wednesday, which I think it's still tight, but you all can give your experts heads up if they are already produced at that point, if they're going to do a redo or supplement their reports. And then I will continue a hearing if I have additional amended or supplemental or amended reports and opinions from your experts. At that point, it's going to be tricky with the scheduling, but then we'll proceed on that. But I do take not issue, but I don't think our hearing was a waste of time. We went through a lot of issues, and I have a handle on those. I just want to close the circle on this to make sure that we've encapsulated and included everything, to include the December 10th disclosures and now these last bit of medical records. And if from that point, let's say nice scenario, we get our records Wednesday, right? A week from today, and your experts are all really diligent and they review it, and golly, in 24 hours, they've decided they either do or do not have a report. Let's say they don't, then let me know that. We will set a follow-up hearing. Let me get to the calendar because we will be very, very tight on time. So we're talking deadline of the 28th. I think we have to do this February 2nd. And I'll say in the afternoon, if you all will look at your schedules. The reason I say in the afternoon generally is because we might still be in trial if we're at punishment. And so we're just queuing everybody in. So if anybody has a problem with the afternoon on February 2nd,
That's fine, Your Honor.
Ms. Labinati, you're scheduling, can you guys accommodate just about anything? That's a
We're
big ask.
we're going to have other attorneys
Okay.
cover other things.
So I'm
yes,
gonna
we're
say,
have to.
I'm gonna say 2 o'clock
Okay.
on February 2nd, 2 p.m. And
2 p.m.
I will say this, you all will update us by the 28th with records and the prospect of having new reports, because this is what I'll say. If we have nothing, then we're going to come to a final on the Daubert hearings. Okay? If there's nothing else, we reviewed, blah, 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 all those things. If we have supplemental opinions, amended opinions, we're going to have a full-blown hearing. So bring your snacks and your coffee or your Starbucks, whatever. And we're going to get into it, right? We're going to follow up with anything substantive like we did at the last hearing. Okay.
That's fine, Your Honor. Thank you.
And that's only, Your Honor, for all the experts or just
all
because
of them,
they're
because I was saying defense, but frankly, maybe your expert has something too. So it's free, not a free for all. It's for all. It's equal for all. So I just will please remind you, we will be in trial, and so bear with us in terms of, you know, emergencies and responses and things like that, because we'll be in a very busy schedule. Unless we don't get a jury, and maybe I'll let you know. We've got 2 panels. They asked for a third one, 260 people. If we can't get a jury out of that, yikes. But we're working. So I really do appreciate, and that, you know, even the long day that we had on the experts, I get it. Let's just wrap this up, and God willing, we can keep our trial date. I'll tell you right now, when we started, I was very skeptical. Very skeptical.
This is my oldest case. It's like a curse.
No, don't say that. Don't say it's a curse. We'll get through it. I'll just be really ready for the CLE.
It's like it's like you know, it's funny because you know I objected to Carlos. Carlos doesn't still talk to me because of that objection and continuance, and here I am. This case keeps on getting
the gift
pushed.
keeps on giving.
That's my curse.
So,
Right.
okay, folks, please feel free to let us know of any unexpected developments. Just make sure everybody's on that email chain. I don't always like to do that, but I know when we're in trial, it's sometimes the most efficient way to do things. So
My motion to exclude, Your Honor, is going to be moved to the docket call. I was just, or do we want to do it here this day?
I'd say be ready. No, I would say be ready for that date on the February 2nd.
Okay.
And if we can't knock it out, then it'll be on the 4th.
I don't think it's going to be very long, Your Honor.
Okay.
Not like the Daubert hearing. I
Okay.
probably think it's 30 minutes, maybe 40 minutes top, but I
Okay.
think it's pretty short.
Your Honor,
Okay, yes, Mr. Peña.
Your Honor, just to make sure that we're communicating, Your Honor. At a minimum, I will submit via email a status report to the court as to what the status is with regards to obtaining those records by next Wednesday, at a minimum.
Okay.
Thank you.
Thank you, Your Honor.
Yeah, I guess the question is gonna be, what happens if we don't get records?
Exactly. So again, I'm hopeful. So at a minimum, I will submit a report to the court.
Bye, Ms. Lavinati. Think
I'm telling
positive.
you, Judge, I
Think-
should have been
think
nicer to
positive.
Carlos. I should have said yes to like the continuance when he asked. Maybe I would have gotten some better karma.
All right.
I'm kidding, Judge.
Let's see. Let's see how we do. Yeah.
Yeah.
We'll live to fight another day. All right.
Thank you, Your
Anything
Honor.
else?
How is the Zoom, Judge, the audio, the sound?
So
I
I
know
don't
the court
know
was
if you
working-
noticed on that date, they were tweaking the whatever it is, the box that we have here in the back, and it was better. I will let you know as we go through this trial, how good it is.
And I don't remember, Your Honor, for purposes of trial, did the court order the expert live or via Zoom? I'm sorry, I just don't
I
remember.
didn't,
Oh,
I
you did.
didn't order it. I just commented that from the last civil trial, the jurors were very consistently not loving video testimony, and that did not have to do with audio. Okay, that I think we still had the speakers at that trial, and it was clear they don't like them. So,
Okay.
if
Right.
I see, the only thing that would change that is that as we get into our criminal trial tomorrow, if I see we're having some real issues, we will put you on notice right away.
Okay,
Okay.
Judge.
For
But
input.
I think most of my doctors would be live. I don't know if one of my expert will be able to, but and I think they're already upset because they're already texting me, when are you gonna call me? And I'm like, oh my God, what do I tell them after today's hearing? So yeah.
And don't forget the scheduling for February 13th, right?
Right,
Yeah,
right.
that's another
right.
thing. And I don't think I've mentioned to you all, well, let me ask, is there anything else on this case?
No, Your Honor.
All right.
Thank you.
Thank you very much. Let's get off.